to get us kick-started.
Lovely.
Just considering time. Good morning to everybody who has joined us this morning, and thank you very much for being on time and for joining the session. Good morning to our lovely facilitator, Zama Mkosi, who's going to be sharing quite a bit about legal contracts, you know, your basic business contract, how to understand this and how to confidently negotiate these contracts. They can seem quite scary to many of us. And I think being entrepreneurs, being in business, dealing with these type of documents, we need to know what means what. And we need to know the amount of leeway that we have when it comes to negotiating. So you can look forward to us covering founding and incorporation agreements. You can look forward to, you know, your business funding documents and how to understand that, intellectual property protection, third-party agreements, and also service level agreements. I think we really deal with that on a regular basis. And sometimes you think that, oh, it's just redundant information that means nothing, but actually it does mean something. And also for you to understand the legal jargon that goes into those documents. What does it mean in layman's terms? So Zama will be taking us through that gracefully so. And you will also be doing questions and answers. We will do questions after each section. So please do pop your questions into the Q&A box that's at the bottom. You can pop all your comments in the chat section and we will be able to see that. But for questions, please do specifically put them in the Q&A box just to make sure that we are able to track that and don't miss anything. I reintroduce myself. It's Mkosi Inc from the Innovator Trust. And the Innovator Trust is really an enterprise and supply development agency. We are quite passionate about SMEs and how to accelerate them, mentor them, coach them from a business angle, of course, just to ensure that they are sustainable entities and looking from sustainability from all angles, you know, internally, externally. And we run these sessions, conversations to innovate almost on a monthly basis, covering you know, your relevant business topics, like what we're seeing now. The previous one was, you know, how to be investor ready and so forth. So please do check us out on our social media platforms and be on the lookout for any new exciting webinars upcoming. I am saying a mouthful. What I'm going to do now is introduce our facilitator and give you a chance to also speak. Those of you that don't know Zama Mkosi, she is a business and media lawyer who has over 20 years of professional experience as a practicing attorney. So she is very clued up with legal contracts. I'm looking forward to hearing that. She's also an investor and a serial entrepreneur, being a business owner herself, CEO and COO of multiple organizations and businesses, both in the private sector and public sector. So I would highly recommend that you do take advantage of the session that we are having with her, and feel free to pop all your questions through into your Q&A box. Zama, I'm going to hand over to you.
Thank you. Thank you. Thank you so much, Mandisa. Thank you so much to the Innovator Trust for putting this session together. And thank you for all the great work that you are doing. I think you were very modest in outlining the work that you're doing, but I really have observed all the good that has come out of it and the impact that you are making into businesses out there. And a very good morning to all the business owners out there, business builders out there. I'm excited to be having this conversation with you this morning. And I say it is a conversation, so relax, grab your coffee. I know that when someone says you're going to be talking about legal things, you already sometimes get, a bit of anxiety. This is not that kind of session. It's going to be very light. It's going to be very simple. I have a passion for simplifying legal principles, for making them understandable, because at the end of the day, it's just one of those things that we cannot do without. We ignore them as business builders at our own risk. And so I really congratulate all of you for taking the plunge and signing up. And I can assure you that you will come out with even if you just understand one or two things better than you did before, trust me, it is going to benefit your business. Before I get started, just as a lawyer, these are just the things that you always have to say. I'm a lawyer, but I'm not your lawyer. I am not your lawyer for your particular case that you may be dealing with. And because I do not have all the facts of whatever matter may be before you. So every information that I'm sharing, it is not to be taken as legal advice, but it is information. It is educational. It is empowering you to know sometimes even what questions to ask. So it will still be information that will save you a lot of time and a lot of money because you know it. And even if you do then have to seek professional legal advice, you may have to get a lawyer for your own lawyer for your particular matter, but at least you will know what questions to ask. You will have done your own groundwork in certain respects. And that in itself, as a lawyer, I can tell you that means I will bill you less hours if you come to me already knowing some of the stuff that I'm going to share with you. So let me share then my screen, Michelle. It says I cannot start screen share while other participant is sharing. Michelle, so maybe you can stop sharing. I can then share on my side so that I can then take everyone through the slides. But as I was saying, you know, business, whilst I wait for Michelle to do that, business is really about relationships, as you know, and everything that has to do with legal when it comes to businesses. Legal contracts, it is just about managing relationships. And so if you really just think about it that way, you will be quite far ahead in terms of just comprehending the contents of all the legal agreements. Michelle, are you going to stop sharing? Mandisa, will you just nudge Michelle? Okay. So I just want that to have that as a perspective, because if you look at it that way, you will get to be less stressed out, if I can call it that, when it comes to legal agreements, because legal agreements are ways that, you know, we run businesses by, we have multiple layers of relationships. We've got relationships as founders of a business. There's a relationship with funders of any business, and we've got relationships with third parties. We've got relationships with our clients, and it's all about how we're managing those relationships. This is what we are going to cover. As I said, we are going to be talking about the principles and some of the critical clauses for the various layers of agreements. As I said, agreements are about managing relationships between funders, between founders. There's also an issue of intellectual property. We're going to touch on that. There's issue of where our business is located, where we run our business from, if we run it from premises, and that is often a big part of our business. There's also obviously a relationship with the team, you know, the actual warm bodies that help us to build and grow our businesses. There's a relationship there, and so there needs to be contracts that come into play there. And we're going to be talking about service level agreements and service level agreements as well at different levels with our customers, with our clients, with our subcontractors. But I will just talk broadly around the principle of service level agreements. So, you know, what is a contract? A contract is an agreement that's created with an intention to be legally enforceable. And that is what makes a difference between a contract and an agreement. Because an agreement, you can agree about different things. You can agree, I can agree to meet my husband for coffee, or meet my husband for a date night once a week. But hey, that is not legally enforceable. That is just an agreement. But a contract, on the other hand, is an agreement that is created with an intention to create legally enforceable obligations. And so that is just the one thing that you must remember, particularly when you're doing business. You want to make sure that you move beyond just simply entering into agreements, verbal agreements, even though there's a lot of agreements that it is not an obligation for them to be in writing, and you can go to court and fight for agreements for them to be binding, even though they're verbal. Yes, you can do that, but for safety's sake, if you are running a business and to minimize your risk, you must always make sure that that your agreements are in writing. Now, you know, when you enter into an agreement, and the reason that you want to make sure that that you reduce all your agreements into writing, obviously you need to protect yourself. You need to make sure that there is certainty. You need to make sure that there is no confusion around what your terms of business are. What are the different expectations between the different parties? And so I think, you know, there's a case that is clearly made for why agreements must be in writing. But now, once agreements are in writing, what needs to go into the agreement? What makes an agreement to be valid and not valid? I've listed here some of the things that you need to consider before signing any contract. Now, most of the time, we find that we are presented with agreements that are drafted by other parties, and there's nothing that we can do. Sometimes you find that you are at a level where your business, you know, there's a bigger party, or there's a more resourced party. They are the ones that present you with the drafted agreement. And so you do not have the luxury of drafting your own. That is not entirely a bad thing, because it can save you the cost of getting your own lawyer. But at the same time, you then need to empower yourself. First and foremost, it goes without saying, but it's worth repeating. Read everything. Read the contract. Do not just immediately feel anxious about the thought that you see a whole lot of pages and you think you're not going to understand. At the end of the day, if it is in English, yes, there may be bits that are in Latin, and we're going to talk about those, but just reading through a document, you will be surprised how you would actually be able to comprehend and understand, and therefore it is critically important. But before signing, these are some of the things that you need to consider. Does the other party have capacity to enter into that contract? Do not take this for granted. Always check on it. Check whether the person that you are signing the agreement with has got the authority. I mean, the other issues of authority are pretty obvious when you're talking about anyone under 18, anyone that is mentally not capable, and so on. But where it becomes tricky for us as business owners is when you've been negotiating with someone, but then you have not checked if that person actually has authority from that company to be the one entering into an agreement. You need to double check on that, because you may find that you are signing a document with a person that actually does not have authority to sign by that company. So you need to check on that, and you need to make sure that you get a written confirmation that the person who is signing the contract is actually authorized to do so. The other thing to look out for is the issue of what laws apply to whatever contract you are entering into. Of course, I mean, you need to, you can't suddenly go into into a coffee shop and sign yourself a contract that deals with mining rights in the DRC or anything like that. You know, it goes without saying, there may be specific laws that apply to whatever it is that you are entering into. So I'm just using that as an extreme example, but do check in and ask yourself if there are any laws that regulate the business that you are entering into. Of course, the legality and the illegality, I think it goes without saying. I don't think anyone in this platform will enter into an agreement knowingly where there are illegal elements to it, because of course that cannot be considered a binding agreement. And also a possibility. These are some of the things that we may take for granted, but we need to check in on them, especially in the days of national lockdowns and so on. Yes, there's an issue of force majeure, which we will talk about, but during that period, for instance, of global lockdowns, it would have been a challenge for you to enter into an agreement knowing that it was not going to be possible to do certain things because there has been lockdowns that are already in place. Contracts that may have been entered into already, that's a different case, but you wouldn't be able to, when you know that there's a national lockdown and yet you enter into a contract, for instance, to host an event for 5,000 people, and yet there's a lockdown restriction to the number of people and so on. So that's what I'm talking about, when you know and that there are existing circumstances that impact the possibility of what you are entering into. So that is just something that you need to really check out for when you are reviewing any agreement. The next issue is obviously the exit, and the termination provisions of that contract. You need to make sure that you are very clear as to the way out. None of us enter into any agreement. In fact, maybe we do actually. We should. It's because a contract of business is not like hopefully a marriage. In a marriage contract, you can come into it with an intention that there is no exit. But for a business, there must always be an exit plan, and it must be clear. So don't sign an agreement where it's not clear how you're going to exit, how you're going to terminate. We're going to talk about some of the terms, but just always keep at the top of your mind how when I want to terminate, whether voluntarily or something changes, does this document provide for how that is going to happen? And obviously, I think the issue of what happens in the event of specific events or particular dates, when does the contract start, when does it end, and so on. So the issue of significant dates is something that you must just keep at the top of your mind. I just thought it's useful to also touch on some of the common mistakes that business owners make when entering into contracts, and these honestly are just I would say common sense, and I think, but these are things that are worth reminding ourselves when we're in the business, because most of us, we're not in the business of being a lawyer. You're in the business of offering services and so on. And so when you're dealing with agreements, it's something that often takes you out of your comfort zone. So it is useful to be reminded of these things. First and foremost, I think, trust your instinct. Trust your instinct. Trust your instinct about a document. If you feel that you're not clear what it means, get a second opinion, because once you have signed, you are bound by what you have signed. And so if in doubt and you have read and you still do not understand, rather make sure that you seek a legal opinion about it, because there's a certain level of basic understanding around how contracts work, which is really the purpose of the engagement today, to just give you a certain level of basic understanding. But sometimes if you don't even have that, you can really just make a mistake and enter into contracts that end up costing your business down the line. Being unprepared for negotiations. You know, as a business owner, you never leave anything to chance. When you get into negotiations, make sure that you know what your position is. Do your homework, have a strategy as to what your walk away point is going to be, what your approach is going to be, and what are you going to be willing to move on and not willing to move on. Because if you do not have that beforehand, you may find yourself really pressured. Once a document is shoved before your face and you have to sign, or a big client is placing a nice big order and it's proposed COVID, you want the business, and you just go without really having done your homework around what could possibly, go wrong and what could challenge me around this business. So make sure that you really do your homework and your strategy on how you're going to negotiate the different terms. I spoke about this earlier. Not reading and understanding a written contract is one of the mistakes. Maybe not understanding can be forgiven, but reading, ladies and gentlemen, cannot be forgiven. You've got to read the agreements and make sure that an agreement is in writing, and watch out for, I know sometimes it seems like a shortcut to just download templates from the internet. It may work for you up to a point, but the reality is that all those documents on the internet really they're not your business. They're not relating to your business, and they may be, each business and each transaction is unique. You may end up with a document that has got a whole lot more clauses that are not relevant to you, or there may be clauses in those templates that really miss out some of the critical things. I mean, I had a client the other time that by the time he came to me, he had used a template from, downloaded a template. It was for a media client, and really found everything else was okay in the document, except the fact that jurisdiction was in Los Angeles. He had actually signed an agreement where he committed that if there's any dispute between them, they are going to go. They're both South Africans, but in terms of the template, they were forced now to suddenly go to Los Angeles in order to settle their matter. Anyway, that put the client in a position where he couldn't really negotiate much, because the reality was that he was not going to be going to Los Angeles. So this is the reason that you've got to really be careful and watch out for those simply downloadable templates. I just thought, let me touch on some of the legal terms that are often used, and I'll be very curious. And maybe during the Q&A, Mandisa, you can tell me what some of the terms that people have come up with, if I haven't covered them, and people maybe can pop some of them in the chat. I've just listed some of them here, and I know they don't cover everything, but I just thought maybe these are just some of the popular ones. The reason that I put the first one, it's called caveat subscriptor doctrine. What it is, it refers to once a party signs an agreement, unless otherwise proven, they are deemed to have read the contents and are bound by the meaning of what they have signed. So this is a doctrine that exists and that applies, which emphasizes the importance of reading the documents, because there is this doctrine that says, if you have signed, you are automatically assumed that you understand what you're signing, and therefore you are bound. Now, the joint and several liability is also one of those that is quite popular and often brings about a lot of confusion. But it is important to understand, when you see in a document that says you are joint and severally liable, what that means is that parties acting together in a contract as partners, they have joint and several liability. So what it means is that together they are liable for everything, and individually they're also liable for everything. So when you see that in a document and you are signing together with someone, you must be clear that between the two of you, the third party can go after each one of you for the whole, and or go, you know, against the two of you for the whole. So watch out for that and make sure you're clear. Another one that is sometimes confusing is the term void and voidable. When people say the contract is void or the contract is voidable, what it means is that a void contract is a contract that cannot be performed at all. From the beginning, the contract is just not performable, because there are certain parts of the contract that don't make it valid. I know in another course that I've done, I'll talk about it at the end. It is available online on Udemy. I go into greater detail around what makes a contract void and not voidable and so on. But for purposes of our quick session today, it's just useful to know that when it says there's a void contract, it means it's a contract that cannot be performed. But voidable means, what it means is that a contract is potentially non-completable, but the party has the party has the right to decide whether they make it to be voidable or not. So it means that it's not automatically an invalid contract, but the party has a choice as to whether to use that right to void it or not. So that is what voidable means. I think without prejudice is pretty obvious. People use it all the time, even in conversations. So hopefully people understand that. Bona fides means good faith. That is what it means, bona fides, and the opposite of that is mala fides, which is bad faith. So doing something or writing something in good faith, and that is what it's about. Voetstoots, I think it's also a popular one, which is relevant when it comes to the purchasing of property, which talks about where, you know, you buy the property as is. And force majeure is really one of those that that has come up quite a lot in especially during the times of COVID. And as I said, that in itself is a lecture, you know, that we can go through as to what amounts to force majeure or not. But I think for our purposes today, just to explain the term, force majeure is a right to remove liability because of unavoidable and unexpected events that are beyond your control. So when those that have happened, you will find that the obligations of within a contract are therefore held in abeyance. What that means is that you are not liable to perform because there was unavoidable and unexpected events that were beyond your control. So that is what the term means. I think everyone, I wouldn't even give a prize for domicilium citandi et executandi. What that means, it just simply means the address that the parties choose to accept service. And it's not something to be taken lightly, by the way, because it can really land you into a situation if you simply put an address there that you know that you are not likely to be in that address for a long time. Another party can issue summons in that address. Once it's in that address, after those number of days, they can issue a judgment against you, and as long as they've indicated that they delivered the documents in that address. So don't just, you know, go too quickly through that and put any address. Make sure that you apply your mind, even when it comes to such stock standard clauses. I will pause there, Mandisa, for now, and maybe take in one or two questions or comments from the chat box.
Awesome. Thank you so much for that, Zama. Shu. especially the terms part, the legal terms. I have seen quite a few of those words. One, not sure how to pronounce them, so thank you for that. And then secondly, you have an idea of what it means because you see it so often, but you're not really sure. So thank you very much for that. I think what really stood out for me, what you mentioned, is that it's so important to read. Agreements can be so lengthy and it's almost draining and the answer is so boring. Do I have to read it? But actually, yes, you have to read it. You have to read it. So thank you for that. Let me visit our Q&A box. Okay, we've got a question from Janine Wood. She has two questions. Can parties enter into a relationship via an electronic contract that are signed electronically? And will this be sufficient, or does it have to be in print for legal purposes?
Yes, it can. The laws have since made provision for that, that it can be considered to be legal. There are certain clauses that you just have to make sure that you incorporate in those in that document that acknowledge that both parties undertake and agree that electronic signatures will be acceptable.
Okay, cool. So I think that does answer your question, Janine. And then we've got a question from Beverly as well. Do verbal agreements have any status in law?
Yes, they do. There are specific transactions that in terms of the law cannot be done verbally. And those are transactions such that transactions that relate to the transfer of property and so on. So there are those specific transactions where the law states that that a verbal agreement is not valid, but a verbal agreement can be considered to be valid. It is just that it is going to take a lot of time. It's going to take a process in terms of proving it, but it doesn't automatically mean that when there's a verbal agreement, then it's not valid. But it's just that it makes your life very complicated and it takes a lot to prove it.
Okay, I guess in the same breath, we can't just, really assume that because it's a verbal agreement, then it stands, is there sufficient evidence?
Yes. There's a lot of gray within that, but it's not an automatic invalidity, the fact that it's verbal.
Okay, perfect. Then Clarence has a question as well regarding the legal terms. Do they have to be cited in the contract, or is it by default applicable, especially the first one?
No. It is by default applicable. The one about that you are automatically assumed to understand. I'm thinking that he's probably referring to that one. No, it does not need to be cited specifically. It is a legal doctrine that applies. But knowing that, when you are signing a document, what you then do is that you can put in a clause that emphasizes that you've seen a line in an agreement that says the parties hereby acknowledge that they have read and understand the contents of this document. So what that clause means is that it re-emphasizes that doctrine in a way, but the doctrine itself, you don't need to actually write it out in the document. Okay,
cool. And then Kumi has a question, or a comment rather. Kumi's comment is that offer to purchase agreements for the sale of property may not be signed electronically. These still need to be signed in wet ink. So yes. Purchase agreements for sale.
Yes, like for instance, in the same vein that the legal especially for the transfer of property, that it cannot be verbal, and even goes for the lease agreements over a certain period, because there may be certain legal restrictions that certain leases over a certain period need to comply with certain specific signature provisions.
Sure. Okay, I definitely did not know that. Would the same that maybe apply to, like, if you're purchasing a vehicle for your company, does that also need to be in red ink, or can those be done electronically?
Especially it is mostly the immovable property the transfer of the immovable property that have that provision. But as I said, that there are things that they may well be valid in that there is no law that says you can't do it, but you just there are things that you would rather just take the best precaution in them. And that's what even most businesses do, that as much as it may be considered legal, and ultimately down the line may not be challenged in terms of the law, but to be on the safe side, they rather do everything physically and have hard copies of everything, just because it really limits, having to fight about such matters down the line.
Yeah,
and challenge signature validity and all that.
Yeah, just be thorough in your understanding and what you're agreeing to.
Completely.
Okay.
Eliminate areas of potential confusion, which is really the reason that you have an agreement.
Yeah. Okay.
Thanks for
That does wrap up our first round of questions. So I will let you carry on, and we will take a lot more questions, guys, in the Q&A box as we move on to the next session. So please feel free to pop those in throughout the session.
Lovely. Thank you. Okay, we're just now going to touch a bit on what I've termed, pre-incorporation and founders agreement. This is just a section that I thought would be useful for most of the businesses that are online, that talk about, as entrepreneurs, we've got, these lovely ideas and that we discuss over dinners and braais, and then we decide that we're going to set up a business, start a business together. And in the hype of the excitement, there's handshakes, and then we go on with implementing those ideas. And sometimes we forget to translate what we have agreed in writing, even before the company is established. So but it is really advisable that it may be that even before a company is officially incorporated, that there are agreements that are signed, and those are called pre-incorporation agreements. And they are very much advisable, because what they do is they really outline they outline the terms that the parties are going to do the business, even as I said, even before the business is established. And there are two approaches to those contracts. We've got the contracts that are dealt with in terms of Section 21, which are the written agreements entered into before incorporation by a person who is acting on in the name of the proposed company. So a person can act on behalf of a company to be formed, that we are going to form this company, but we know that we haven't established the company. But in the meantime, I, as Zama, enter into contracts that are going to benefit the company when the company is ultimately established. So when those are done, they have to be ratified within 3 months of incorporation. And then you also have on the other side of the screen, where I talk about where a party enters into an agreement as the agent. Well, not as the agent, but they are the principal. They enter into it in their own name, but they know that they are doing this for the company that is still going to be entered into. And for that, we have a standard principle, which is called stipulatio alteri. And yeah, don't be stressed about all these Latin names. They actually, do have English translations, which I've put on screen. So those kind of agreements, can be ratified within a reasonable period of incorporation. And but as I said, as much as there are these provisions for pre-incorporation contracts. In our days, I think it is actually most advisable that when you decide that you're going to go into start a business, register your business immediately, and then do and enter into contracts, once the business is in place and in the name of the business. Just once again, to really avoid the issues of having to be caught up and lost in translation. And but there may be, agreements, as I was saying, between founders, because the agreements that I've spoken about are agreements, with third parties that entered into by an individual who may be the founder, either as an agent or as a principal, for the benefit of the company to be formed. This slide here for founders agreement is making reference to what I started off with, where two buddies over dinner, they agree that they are going to be starting a business together, and then they enter into an agreement. This agreement may ultimately become a shareholders agreement or not, but I will talk about what may be some of the differences between the founders agreement and the shareholders agreement. But the reason that this is important, as I said earlier, it is just to avoid any disputes down the line, between co-founders. Whatever was discussed upon when all was good during the dinner party, and now things have not gone smoothly and you have no agreement, then you're going to have problems. And also there may be, unforeseen circumstances that come up, unforeseen circumstances that really need to be catered for. You have to think about those before they happen. And that is why it is really advisable to have a founders agreement. So an agreement between, 2 or 3 people that decide that they are going to start a business together. Even perhaps before you sign a more complicated shareholders agreement, you may have not worked out the details of a shareholding, but at least do put something in writing, Uguti. For now, this is what we know. This is who we are. This is the business we are going to enter into, the business we're going to be in. These are the different roles and responsibilities. We designate Mr. X is going to do that, Ms. Y is going to do that. And this is how we see ourselves splitting equity between ourselves. And this is how we see the issue of intellectual property, without even at this stage complicating it, but really just saying we are going to enter into a business of designing sneakers. Dumsani is going to do the designing. Terence is going to go find a supplier for this. And Mandisa is going to be doing all our digital marketing. Even that, and whatever the designs that Dumisani is going to do, this is what's going to happen to them. Put it in just plain English as a start, because doing that will also empower you, even when you engage with a lawyer, to put everything in writing. Just between yourselves as co-founders, you must have at least dealt with some of the, if not all of the provisions that I've listed on the slide now. Talk about the issues of restraint of trade. Talk about, now that we are starting this business together, can the other founders also have other businesses? What type of other business can they do? Does the fact that Dumsani is going to design sneakers for us, this new business, can he design for other businesses as well? Yes or no? And so on. So make provision for those kind of things. Issues of confidentiality from the word go, outline how we're going to keep the information about this new business that we are still building between ourselves. and the expenses. If people are going to be incurring expenses even before because there's a lot of work that needs to be done before maybe there is funding into the business. How is that going to be provided for? Is it going to be reimbursed? Is it going to be considered as a loan into the business? You know, how is that going to be dealt with? And I said earlier, there must always be a way out. There must be a way out, even for a founders agreement, and a way out as well, whether in for good or for bad. Because sometimes that way out may be that it's as a result of performance or non-performance. What if the Domisani who was supposed to be designing our sneakers suddenly does not do a good job, with the designing? Do other founders have a right to kick him out or not? What's going to happen if suddenly the marketing strategy is not delivering? What happens? Think about those things. Think about those things, from the word go. And even for the issue around the equity of rules and obligations between yourselves. How are decisions going to be made? In a founders agreement, as well as in the shareholders agreement, it's always important to look into the decision-making mechanisms, because this is also one of the areas that are often a challenge when there is more than one, founder in a business, that there is no document that outlines how decisions are going to be made, who's going to have the ultimate say, and what decisions are going to be made. It's often advisable, maybe at this stage, to say Mr. X will decide on this, or this is how we are going to vote around whatever decisions, because failing to provide for those instances may really end up really compromising the relationship and compromising the business even before it starts. And yet, if it is outlined, if there's a dispute, everyone can really just go into the document. And as I said, shareholders agreement is really the next level of detail when to just a founders agreement. And because the reason that there's a slight difference is that the founders may well not themselves be shareholders. There may be a different entity, maybe there's a founder, but then maybe the shares on behalf of that founder are held maybe by their family trust or something like that. There may be different structures that come into play once you get into the shareholding. And so that's why there may sometimes be a difference between a founders agreement as well as a shareholders agreement. But it pretty much has to provide for all of those issues that are raised around what are the rights of the different parties, what shares are held, the decision-making, profit split, and those kind of things. And they need to be dealt with. And obviously to underline what happens to the terms that were in the founders agreement once the shareholders agreement is in place, because obviously the two cannot at all times apply together. So now these are, I think I've outlined some of these things that are terms that need to be in the shareholders agreement, that now you get into the election of the board, because you may have had a funder that also wants to be provided for. Maybe a funder takes equity in the business and therefore needs to be provided for in the board and so on. So these are some of the things that you will have included in the shareholders agreement. Okay, I will take the next batch of questions. I'm trying to move now very swiftly.
Awesome. Thank you so much for that, Zama. We do have some questions. Okay. So if you have standard terms and conditions for rendering a service and your client makes payments on invoices which references the terms and conditions, could this be upheld in a court of law and provide your business with some protection? Example, for retainer services.
Example, the what? Sorry, what services?
So an example would be a retainer service. So basically with the terms and conditions stated on your, okay.
Yes. And we were going to talk about the SLA, but absolutely, because those are the terms of your doing business as a provider of, whatever services are, that payment is made this way and that way. And absolutely, if everything else about that agreement is valid, and so, yeah.
Okay, so even though it is stated on an invoice that I imagine the client doesn't really sign, but they're making a payment against this invoice, and the invoice states the T's and C's.
Oh, so is that what she said? Oh, okay. I thought I missed that part when she was saying, I thought she was saying she's got terms of business that are then outlined in the
in the invoice.
That are outlined in the invoice. Yes, because there is when you're entering into a contract, there is and as I always say that there are things that you can go into the courts and argue, and ultimately down the line be able to prove that there is validity. However, especially if you are a SME business, I really would advise that you do publish, and even when you publish your terms of sale, you publish your terms of sale, you even before, let's say, retainer services, you have a contract with them, because I think that person that asked said something about there's a retainer. They're in a retainer business, that therefore, even before you get to the point of invoicing, but you invoice at the back of a retainer agreement, you invoice at the back of having signed a retainer agreement with that client that outlines what services you're going to deliver, how those services are going to be measured, and how they are going to be compensated for. So I really would not advise just leaving it to outlining the terms on the invoice, in that instance, but to really just, even if it's a one page, it does not have to be a complicated, agreements don't have to be complicated, but at least they need to be clear.
Yeah, and I think the one thing that also stood out for me in just this part that you've covered before this Q&A was the importance of detail. I think that becomes the most important thing. What you do detail on your agreements needs to really give some thought into that.
Yeah.
Okay. And then our other question is, how do you protect your business against divorce when you are in community of property?
That is also something that I wanted to mention as the reason for the for the founders agreement, and to provide for in the event even of not only the issues of marriage, but and the terms of marriage, but also the issues of in the event of death or anything like that. And so you really need to outline in the founders agreement how you're going to deal with that. But also when it comes to being married in community of property, there are also sections that you can look into that may exclude when you are entering into agreements for business purposes. But that is always a fine line, but it is arguable that this contract I entered into, it was for business purposes, and so it may be included. It may be excluded from in community of property assets, but I would really look at that very carefully and rather make sure that you consult in order to find out exactly where your particular what your particular contract states, especially if there's shareholders or founders contract that is in place.
Okay, awesome. And then for a business that's a PTY Ltd, is the shareholder agreement a mandatory requirement?
It is highly advisable for every highly advisable for every type of business. veritable, if there's more than one owner, and you know, between yourselves as the co-owners of that business, I would highly recommend that you absolutely have a shareholders agreement between yourselves, because it deals with all these issues that I've stated. And if it is not there, then you are leaving a lot to chance. You're leaving a lot to chance, and you are building, you're not building on a solid foundation. The two of you may be great friends today and building, but life happens down the line, and you don't want to put at risk what you are building.
Yeah. And I guess, you know, you'd rather get the agreements in place while things are still going well, rather than
Best time to do it.
Yeah, best time to do it. Best time to do it. Okay, Dombikona has asked that we please go back to the previous screen. So I think we can just keep that up for her. Yeah, so Dombikona, if you do have a question pertaining to this screen, please do feel free to pop it into the Q&A section, and we will cancel address it in the next round of questions and answers.
All right,
yeah, let's move on.
Yeah, I'm worried about our time. These business builders have to keep building their businesses, and okay, all right. This section, we're just gonna touch high level on intellectual property. Intellectual property, as I said, is another day-long session on its own. But for our purposes today, I just wanted to just give high-level definition of the different types of intellectual property and some the registration processes that are involved. We know when building our businesses, it starts with an idea, it starts with an invention, a creation, and there's a lot of intangible assets that are part of the businesses that we are building, and they are all termed intellectual property. And the whole aim of intellectual property laws is to make sure that the owners of such creativity are protected, and they are right to use those inventions and those creations are protected, so that they can exploit them for their benefit. That is the whole idea. That is the whole idea behind it, that people don't end up using what you have created. But it gets very, slightly complicated. And I think it is one of those areas that definitely I wouldn't, go on it alone as a business owner, because it gets very technical around what amounts to what type of intellectual property, what you are able to protect, what you are not able to protect. And when I first started as learning about intellectual property, or around 20 years ago, the one thing that my principal, when I was still a candidate attorney, told me was that you can't protect an idea. And that for me seemed very counter to the whole concept of intellectual property law. But that understanding that for me has really been an anchor in understanding intellectual property law, that we all have ideas. There are no new ideas under the sun. An idea on its own cannot be protected. And just an idea that is floating and it has not been translated into something tangible, you cannot protect it. And hence even, the definition of intellectual property, and I'm trying to find one that I can read as is here. I'm sure I'll find it just now. But the point that I'm making about it is that idea needs to already to have been translated into something that is tangible for it to be protected. So you can't see someone doing something and say, oh no, but I already thought about doing coffee like that. And so, mobile coffee, whatever like that. You can't. You need to have translated it into something that is tangible. Hence, there are different types of intellectual property: trademarks, patents, copyrights, designs, and these are really some of the ways that the whole idea of intellectual property has been broken down. Like, for instance, a definition of trademark. A trademark is a device, a name, a signature, a brand name, a slogan, which is used to identify and distinguish goods and services. Distinguish is a very important factor because it has to be distinguishable. It has to be distinguishable. It has to be unique for you to be able to protect your trademark. It has to be considered by the registrar that it is unique. And I'll give you some examples now of cases where the issue of being unique or not unique has been called to question. Now you also have patents, and patents, they provide inventors with the right to exclude others from making use of their patents. And patents, what are patents? Patents are, physical inventions or novel processes that offer a technical solution to an issue. And patents, once again, ladies and gentlemen, is also one of those that is a very technical space. And so you need to make sure that you absolutely consult a specialized patent attorney when you are looking into registering a patent. Do not go on it alone. I mean, one of the 3 requirements, for instance, to register a patent is that it's going to be new, it has to be inventive, it has to be useful, and there are certain things that you need to have in place in order to be able to prove any of those things for you to register a patent. But also, don't hold back on the basis that you can't afford a patent attorney, and so in the meantime you're just going to go ahead and do what you need to do, because you may well also be compromising your registrability and your ability to protect your patent if you keep going on and using your patent or doing going around and looking for money for your patent without having protected it. So rather make the investment of consulting with the patent attorney from the word go, so that when you go around, because sometimes you find that you can lose your rights by really publishing your patent out there. Now, copyright, copyrights, protects the rights of a creator of a literary work, an artistic work, an expression of ideas. And this goes to what I said earlier, not the idea on its own, but the expression of an idea. Once the idea has been translated into some form of work, in some form of literary work, or some piece of music, or some piece of design, or some piece of film, computer program, that's when, it can be protected. And the copyright vests in the author of the work once the work is created in a material form. This is exactly the definition that I was looking at, and the importance of translating it into something that is material in order for it to be protectable, and it has to be distinguishable. I made a point about that, and I wanted, for instance, okay, it's not the case slide. I'll go to the case slide now. This is just high level, the process of registering your trademark, and the trademark can be. I want to go to this slide. Which mark? Okay, the trademark can be a mark that is, it can just be the words, or it can be the words together with the mark. As you see the Mkosi Inc on my thing, so I can register just the word mark Mkosi Inc without the logo, or I can do the word mark as well as with the design mark. So those are two different things. And because sometimes you can get a whole lot of Mkosi Incs out there that do not have this same logo. So in terms of the laws, I can register the two, I have to register both of them separately if I want protection for both of them together. Now also what becomes important are to think about the classes where you are protecting and registering your trademark, your logo, the design of your logo, what area of business are you in? You've got to think about that. And you can register for the class that you are doing business in, or you can register sometimes in a class for defensive purposes, the area of business that you know that you are going to extend to. You may not be there at the moment, but you know that you have intentions of getting into that area of business. And so right from the word go, you want to be able to register your brand, your logo into that class as well, because you don't want to only start once you've already built the brand, because maybe by the time you do that, someone else would have registered in that class, and you find yourself that your ability to register is now compromised. Hence, the recommendation to conduct the availability search. To start with that trademark search. It's not compulsory to do it, but I highly recommend that you do it. When you think about registering your business name, your logo, start with the trademark search is what I would recommend. And please, just to make everyone aware that registering with CIPC, registering for a company name is not trademark registration. You can have a name of Mkosi Inc registered as a Mkosi Inc Pty Ltd, but it does not mean it automatically gets registered into the trademark register. Those are two separate processes. So just because you've got your name, a company name, just because you've got a domain name, just because you have a website, that does not mean that you have trademark registration and trademark protection. You still need to go through that exercise. So watch out for that. And so this is largely the process, doing the search and then doing the application and the process that I've outlined there. I just wanted to highlight quickly, one or two cases on the issue of trademark. This was a case that was decided. What year was this? I'll give you the year. 2022, in fact. Around the use of the word soul, soul kitchen. Now, golden fried chicken, they own a number of trademarks that incorporate soul, for obvious reasons, chicken licken, soul food. So they went and registered a whole lot of different trade names with soul this, soul that, around, the issue of food business. And one of the trademarks that they have is Soul Kitchen. And now this company came and had this as part of their name. And then obviously they were challenged. And I think just before the matter went to court, they then changed Soul, S-O-U-L, and then they changed it to Sol, S-O-L. And because of that, then the court held that, okay, now there is no issue because they are different. But for as long as they had the soul, which was the same soul as that, they were really facing a challenge of being of breaching Chicken Licken's, well, Chicken Licken is not their trade name. I think it's Golden Fried Chickens Pty Ltd, of challenging their trademark. So it's important when you're a business owner that you are building a brand, make sure that you're not busy building a brand that is actually likely to be challenged by the owners down the line. And this is another example, Yappy, this case between Yappy Chef and Yappy Gadgets. and Yappy Chef were challenging Yappy Gadgets on the basis that they are passing off, using the name Yappy or for their business. But in this one, the court held that, Yappy is now a normal English name. It is now a normal English name that is not unique and distinguishable, to the business. And so Yappy can't claim that, Yappy Chef can't claim that they have exclusive right to the name Yappy, because it is a standard English name. It is not necessarily a name that is registered to them, that belongs to them. And so they can't claim that they've got exclusive rights to it. And I think this also just shows to us as business owners that the whole concept of creating new words, it is not just for the fun of it, but it's also to protect ourselves. You rather create sometimes a unique name that does not exist, that plays around with your brand, and then build on that, and not just rely on normal English names. You may not necessarily have the ability to create exclusivity when it comes to those. Okay, let me take quick questions, Mandisa. I'm speaking as fast as I can. Almost there.
I wanted to check with you, Zama, before I dive into our Q&A box. If you can just go back to the previous slide, please, with Yappy Chef and Yappy Gadgets. So with Yappy Gadgets, we can see the TM on the top, my right-hand corner there. Does that mean they've trademarked their name?
Yes, they've
Okay.
The TM, they've registered.
Okay, so can they then actually sue Yappy Chef for using the term Yappy, or was it just the logo that they've registered?
No, in this case, it was Yappy Chef that raised the issue with Yappy Gadgets. Mm-hmm. They're saying Yappy Gadgets was using they didn't have the right to use Yappy. but then the court said that Yappy is not an exclusive. In fact, their exact words were this. Their exact words is sorry, I want to read. They said the court noted that Yappy is an ordinary word in common use, and the aim of trademark is not to secure a monopoly of common English language to any one company. So that's why Yappy Chef's appeal was rejected.
Okay.
It wasn't unique. Yes.
Okay, cool. And then you also made an example of Mkosi Inc that you have, you've registered both Mkosi Inc and the logo separately as two separate trademarks. Does that also mean that you can use the two separately on any legal documents? So we could sometimes maybe see just your logo without Mkosi Inc because they're registered separately?
Yes, you can register, because if you register them separately, then you have a right to use them. You can register them separately and together.
Okay.
So you can register Mkosi Inc just on its own, and then you can register it when it looks together. It's always sometimes advisable definitely to do it together, especially if you always want that association, that that brand association. I'm sure the marketing people in the space can speak more about that, but yeah, you need both. It's advisable.
Okay, then we've got a question that says, thanks for these valuable insights, Zama Mkosi, truly appreciated. To protect our IP, we've applied via CIPC to have our product name registered. We have got our notice of acceptance and it was submitted for publication. This week, we received a notice to say that a well-known international film company has opposed this, and they have been given an extension till January 2023 to submit their case, etc. It's probably likely that they would succeed, given that they are a big international company. If we cannot trademark the name, do you think it's likely that we could still use the name going forward?
Well, if it is opposed and successfully opposed, it means that you probably then will not be successful in confirming in it being registered in your name. So you would not have the right then to use it.
Yeah. So I think in this instance, they would need to then see the verdict of the case, and if it's successful, they can't utilize the name.
Well, that is the outcome. That, you know, if that is the outcome, we don't know. I think they even though they may be big and all that, but they still have to make a case as to why they are challenging it and so on, and the registrar is the one that will make a ruling as to whether they are in agreement with them or not. But obviously it does not stop the person that asked the question for them to make a business decision in the meantime. So they need to really consider their options sooner rather than later, and really consider what maybe what investments they've already made in building that particular brand so far, and are there any alternatives that they can look at, and maybe if they can wait, because perhaps January is not that far off, if they can wait but instead not make any more investments in building in the meantime. I think they will have to really, in my view, just make a business decision about how they handle it whilst they wait for the final outcome. But size does not automatically mean that they will be successful. Many are bigger corporations. They've not been successful because decisions have been made that actually it does not conflict, or the other party is maybe in a different class of business and so on. So it's not a given.
Okay, it's not a given. It's not a given. So that's with trademarking the name. Can you trademark a phrase? For example, just do it. And then also, how do you tie this back to your business?
Yes, you can. You can trademark a phrase, but you will find that the registrar may also put certain restrictions to that, and say you can't, for instance, it can be used only together. You can't use them individually, because you can't use just, so you don't have a monopoly on just or on do or on it. But you may well be able to use it together. So I like that question, that it emphasizes it as a phrase, but not the individual words, because they are just English words.
Just do it. Okay, brilliant. And can one patent their research thesis with an intention to develop a project out of it?
Any written work, the fact that it's your corporate, the fact that you've written it and it's got your name on it and it's got a date on it, it's automatically considered yours. You cannot, you don't have to go register your book. You don't have to go register your thesis with the registrar or anything like that. So as long as hence the advice is always that whatever you write and you date. In the old days, there used to be actually a recommendation that you send it to yourself by mail, because you always need something that is going to be an independent, objective evidence that it belongs to you and it was written, or it was an original written by you on this date, so that if someone else does the same thing after this date, then and so on. So nowadays you can do certain things. I mean, if it's a thesis, I'm assuming that even submitting it to that particular school, and maybe even sending it to yourself on email and so on. But also on the thesis, I think the person must just watch their agreement with the school, because sometimes those schools actually retain copyright to the thesis. So she must read the fine print, or he must read the fine print.
Yeah, because before you know, it becomes property of the school.
Yeah, sometimes.
Yeah. Okay. Web name URLs are very tricky. Keyword search SEO is critical. Can I own the use of a specific keyword, that is, extend my trademark ownership to SEO?
As I said, with simply owning a domain name does not protect, does not give you that intellectual property or protection. Does not it may give you popularity and everyone identifies with it, etc., but you go and do a trademark search and find that actually that mark is owned by someone else. The fact that they have not challenged you on it to date does not mean that you ultimately own it. You may well still be building it for the benefit of someone else who one day can successfully challenge you on. So I always advise that before you go on building any name, a brand for yourself, do a search and be sure that you can own it and it can be yours, and then you can start the work of building its credibility, because otherwise you may be working for a third party.
Sure. In the instance, where you have been building your brand and you do not register it as a trademark, and then you find that this is already existing out there, is there any way, and if you can show that you were first with this particular trademark or with this particular brand, is there any protection for your business in that instance?
Well, it takes arguing. you can argue your point before the registrar, but it is really going to not work in your favor that because when someone else has registered it, there is no obligation to use. So I can register, if I register Mkosi Inc in 2007 and it belongs to me and I have not used it, and someone comes with Mkosi Inc in 2017 and starts to use it, they can't say, oh, but and they don't register and they don't check who owns it. It won't be a defense for them to say, oh no, but you never used it. But I got in there first, I registered it, it was under so hence the whole process of searching if it's available for use. Otherwise, it may not be yours. You can use it, and for as long as someone doesn't challenge you, but the reality is someone out there has a right to,
because they were not opposed.
And they may just challenge.
Okay, I'm going to do one more question out of the three that we have, then let you finish and we'll continue with the questions.
Yes.
Just with relation to the international film patent story, Ntombi is asking can they change their jurisdiction perhaps and keep it to the country or the continent? Would that then make a difference?
Well, they can play around with that. They can try. Play around with the registering in different jurisdictions, but even for that, they different jurisdictions have different powers, if I can use that word, and you find that sometimes when you register in this jurisdiction, it applies wider than in others and so on. So I would approach that very carefully and really just look at the specific facts of that case. I would think of that. But it's not impossible to have ownership on the one and not on the other. It's not impossible. But sometimes whether it's effective or not for actually doing business, that's also maybe a business decision to be made.
Okay, cool. Zama, I'm going to let you continue, just also thinking of time, and then I think we can do one last round of questions at the end.
Yes. I will breeze through the remaining ones. I think what I wanted to touch on was commercial lease and also just simplifying it as much as possible, just giving you high-level basics. This is also one of those areas that I really would advise that know the basics, but certainly make sure that you do consult a lawyer before you sign, that long commercial lease, because they are often, there are often legislations that change quite frequently, that affect the issues of commercial lease. And they particularly when it comes to the CPA, the Consumer Protection Act. And so it is, it's not one of those to go on it alone, but just to give you high level, at a basic level, really a commercial lease agreement, has two main components. Somebody's going to give you rights to use the property, and in return for that, they are going to be entitled to receive rental. So it's two-way rights and responsibilities. That's always just something to keep in broad perspective, that there's going to be what your rights are as a tenant, as well as your responsibilities. The same with the landlord. They're going to have certain rights and responsibilities as well. Now, for commercial property leasing, in South Africa, as much as large part of it, is dealt with in terms of common law. For commercial leases, there's quite a few parts of it that are governed by the Consumer Protection Act. Generally, Consumer Protection Act is really just one of those an act that really is a very good act for protecting consumers and against exploitation by the bigger players, and the assumption is always that landlords have more negotiating muscle, and therefore consumer protection comes in to challenge and protect consumers. For example, one of the things that are one of the sections that the Consumer Protection Act protects the tenant is exactly the doctrine that I mentioned earlier, the doctrine that assumes that the caveat subscriptor doctrine that I mentioned, that the one who signs is always assumed that they understand. In terms of Section 22, the obligation to understand the terms of the lease is placed on the landlord. And what that means is that the landlord in a commercial lease has to go into greater lengths to show that they have communicated and they have clearly outlined the terms of the lease. So maybe if you are a landlord, for example, you need to make sure that your commercial lease agreements, you use easily understandable language, you break down particular terms of the lease, particularly those that relate to the financial implications. You itemize and give a breakdown of the financial obligations. You explain the obligations in simple language and simple terms, because in terms of Section 22, you are the one as a landlord who has an obligation to show that that you gave clarity of the terms. So you can't, as a landlord, have this 50-page document, half of it is in Latin, the tenant has signed, and then, signed for 20 years a commercial lease, and then say they should have read and understood. The Consumer Protection Act comes to the rescue of the tenants in that regard by shifting the responsibility to the landlords to make such documents as easily understandable as possible. But still, having said that, I know they may still not seem like they're easily understandable, but I think there may be instances that landlords can prove that they've really gone out of their way to itemize the terms and made them as simple as possible. So yeah, another section that is relevant from the Consumer Protection Act is Section 48 and 49 of the Consumer Protection Act. which provides the terms of an agreement that are deemed unfair, unreasonable, or unjust. Because in this way, and in terms of this section, you are protected against certain clauses that indemnifying the landlord, because these are also one of the clauses that place heavy obligations on the tenant. So these are always watched out for, to make sure that they are not too much in favor of the landlords and they compromise the tenants. Because in this way, landlords always go out of their way to say they're not responsible for this, that, and the other. And it's really up to the tenant also to make sure that you are clear about what risks fall under you and what risks will remain the liability of the landlord. So when it comes to commercial leases, I think it is still very clear and critical to make sure that before you sign, you fully understand your areas of liability. Another area that is important for commercial property leasing is termination. When can you terminate? How can you terminate? Once again, yes, there are areas where the Consumer Protection Act can assist you if you are an individual, that if you sign the commercial lease as an individual, you can give notice, written notice more favorably than when we're a juristic person. But I always say, don't just rely on these as a tenant, but always make sure that you fully understand and comprehend what are the terms of exiting that lease. Because we spoke earlier, exit clause and exit provisions are critical for you to fully understand. Another clause in the commercial lease that are critical are issues around rental amount, exit strategy we've spoken about. The rental amount, what is it, how it's going to be calculated, because for commercial leases, in certain commercial leases, you'll find that the rental amount is linked sometimes to revenue, and it's linked, so you need to be clear if there's any such provisions. And also it goes without saying as to what is going to be involved, what's going to be included or excluded as part of that rental amount. And escalations, it's also one area to look out for. How is the rental amount going to be escalated? How, by how much, and how often, at what intervals? That is something that is also quite critical to make sure that you don't just gloss over and you fully understand what is involved. But I think I know I rushed through this one because I just have the last one, the SLA, that I also just want to get into, and we're already quite tight on our time. So I'll take questions on this one, Mandisa, and then I'll get on to the last section.
Okay, perfect. We do have a few questions on this one. With the COVID-19 pandemic, it demonstrated that landlords have little sympathy for tenants. What are typical circumstances that can allow a company to exit a lease before the end of the lease period?
Well, those circumstances will depend on what the contract allows. Hence, there would be the terms of the contract and what are the exit possibilities. And obviously also depending on what circumstances have arisen, for the tenant, whether, the tenant can look into the Consumer Protection Act, maybe for a way of exiting by saying they are a natural person and therefore, they can give notice in terms of that, or can a tenant claim a force majeure of some sort that there's been floods, and there were floods that happened and then the place was rendered non-habitable, or there was a political unrest, and therefore the political unrest then impacted their business and so on. So one would really have to look at the particular circumstances and look at the document itself and see if there are any, I wouldn't call them loopholes, but and see what are the exit opportunities that are in the document.
Okay. Speaking of exit opportunities, if a landlord ignores my high credit risk and extends a lease which I can no longer afford, can I walk out knowing I am protected by the Credit Act? Do I need to show that I did declare my risk and risk of the business and the market? And also, where does the responsibility start and stop?
Oh, that one I think is very technical and very unique, because because I don't think that one, and I wouldn't even want to even try and give a generic answer, you know, to that, in my view, because it will have to be very specific to what have they already presented to them, and what is the period of the lease, what is the status of the entity. So I think there's many, you know, eventualities to that I really would be careful to just give a broad response to that.
Okay, so I guess that one is really specific.
It needs it must be someone responding in the capacity of as your lawyer. It is one of those. It is one of those. Yeah.
Okay, no problem. And then the other question around property is, I'm renting a unit that I still pay bond on. Obviously, the rental money will go towards the bond payment. My question is whether SARS would want a share in this regard.
Oh no, I'm not tax. I think I wouldn't be the one to ask when it comes to when it comes to what SARS would ask. No, I wouldn't want to venture into that one, Lisa.
Okay, no problem. I think that does cover our questions for property, and then we've got one or two questions on trademarks, but we can do that at the end.
Yes. Okay, all right. Also for SLAs, I'm going to breeze through them, because as I said, I like these to consider these things more as oh gosh, it's not SLA yet, we're still employment contracts. Oh my goodness. Apologies, you know, with people and time. Oh, we're still in employment contract. I will also just go through this very quickly. Mandisa, what should we still continue? I don't know what your protocol is around.
Please do continue, Zama. I will flag a cutoff time if there's a specific one, but please do continue. I do believe there are still some attendees who will find great value. Yeah.
All right. Okay. Great stuff. I'll be quick. Okay. Employment contracts. I forgot about the very important relationship in our businesses that we need to regulate. This is the relationship with our the team, the people that make it all happen, and the people that are employees. This is also a very it is a highly regulated area, because obviously of the basic conditions of Employment Act, the LRAs, and the issue of the unions, and so I'm just giving you high level information at this stage, but there may well be very specific and unique circumstances that relate to your particular status of your employees, but primarily the agreement of employment between yourself and your employees, it's still no legal requirement that it is in writing. Let me just put it out there, but also equally put it out there that definitely does not give you, I think, a green ticket to not put it in writing, because instead I will put it exactly the opposite, that there may not be a legal requirement, but it is something that is highly advisable, because otherwise, there's confusion and there's conflict, and it's not provided for. But having said that, there are still even certain sections that you do need to outline in writing between yourself and the person that that is your employee. Like, for instance, the employee definition that I've put up what an employee definition is, and that employee definition, I think it speaks for itself, and the reason that you need to have something in writing is that you need to clearly outline the type of employee status that you are entering into, and these are some of the different statuses, whether you are employing someone as a temp, as an independent contractor, as a fixed term contract worker, or as a permanent employee. And just to indicate that this one here, the independent contractor, even though I've listed it in here, but it is not actually a contract of employment, because and it's something that I know that more nowadays now we engage a lot with, we run sometimes, small, medium-sized businesses that we do not keep a big workforce of people that are permanent employees in our businesses, and we contract them as independent contractors. It is always important to be clear that that document clearly outlines the independence status of that party, so that there is no confusion between that party being an employee, whether they're an employee or whether they're an independent contractor, because of course there may be implications whether they're an employee or not, whether in terms of the act, or even more importantly, even in terms of some of the provisions that relate to intellectual property, some of the provisions that relate to the work that they create, that person that you've brought in to do just a small project for you, because as a subcontractor, that person, what is the ownership status of the work that they create, because it may apply differently if they're an employee or if they're an independent contractor. And hence it's important to always have in writing and be clear how you are treating both of those instances. You do not want a situation where you bring in someone as an independent contractor, they create a whole lot of intellectual property for your business, and then next thing, there's a fallout, and then they leave, and then they say everything they've done belongs to them or something, simply because the agreement did not make provision for that. Or when it comes to a fixed term contract employer, that there was confusion where the person, they thought they are permanent, but then they're on fixed term contract. You need to be very clear, because there can be a very fine line between a person assuming that they are now permanent versus a fixed term contract. Hence, this is probably also one of those areas that I would not advise going on your own, and not seeking legal advice in terms of drafting contracts of employment or independent contractor contracts for yourselves. The contracts that take into account your unique circumstances, as to whether you are bringing in people that are independent or people that are fixed term or permanent. So, because you don't want to leave it to the definition of the act, because it may also really just compromise you at the end. Now, certain essentials in terms of employment contract, you must obviously be clear what services are going to be rendered, the description of the role that the person is coming into. Non-disclosure is a must, is a must. Please make sure that you always include that. Non-disclosure, compensation, obviously, how they're going to be compensated, whether there's going to be any additional compensation for leave or anything like that, and when that is going to be paid and so forth. Now, also with other provisions, obviously, around what benefits they have, leave in the event of incapacity and things like that. I guess like the commercial lease document that I spoke about earlier, please just start off with using, even if you have not consulted a lawyer, or even if you've consulted a lawyer, lawyers often need to be reminded to keep things simple. And because you can have a document that looks very complicated that even you as an employer do not understand, how much more your employee. So always use, plain language. Technical terms must be defined. Make sure that the contract is properly signed and copies are kept by yourself. You also give the employee a copy as well, and make sure that there is a copy also with the third party, whether your HR person, even if that HR person is perhaps outsourced. And here are some tips on what not to do. I think most of them just talk to keeping the document, very simple and outlining what are the roles and responsibilities of the different parties, and without making any assumptions that even the parties involved understand what the clauses mean and so on. So don't assume that, oh yeah, we spoke about this when you came in, that we're going to do this, but then the document itself does not outline what is going to be done. And also make sure that you look at your contracts periodically, because if anything has changed in terms of the role that you are expecting the person to do, you need to make sure that the contract is constantly updated. Can I go through this, just the last part as well, Mandisa?
Yes, please.
Questions at the end, maybe for the sake of time. Okay, all right. And I think for this is just the last part, which, I've termed, the service level agreement. And the service level agreement, the way that I would like you to look at it is, a service to whoever you're rendering the service to, whether it's to your client, or whether with another third party that maybe you are a subcontractor to, or who you are subcontracting with. It is really just a document that outlines, that regulates the relationship and the expectations between as the provider of a service and the person who is going to be receiving the service. That is basically it. Sometimes we think, all these complicated terms, SLA, they look fancy, but they sound fancy. But at the end of the day, it's about, this is what the other party is going to do. This is what the other party can expect. And this is how much is going to be paid for it. And this is what do we do if something goes wrong. And this outlines, in this slide that I've got here about key features. What are we agreeing on? What is the overall objective of what we are contracting about? And how do we describe the services? You're supposed to deliver XYZ, this number of times, and so on and so on. Describe, make sure that there is clarity in the document. What is the standard of service? What is the level of service? Are you clear? If you say you are going to building the road, definitely you must have clarity of what the level of service to be expected is. But as much as possible, whatever your area of business is, make sure that you do put in something in there that can objectively be considered that this is the expected level of service. And it must be something that both parties have agreed upon and they've signed up on, because the whole reason that we have an SLA, you want to make sure that there is no confusion. And so then there cannot be confusion around what is the standard of performance that is expected, because this is one of the areas that often cause the greatest potential for conflict as to, yes, you performed, but your level is not what I expected. So make sure that the document is very clear around the standard of service, because the standard of service need not be, the best possible, at all times, but it is what the parties agree on. Because there may be issues that relate to budget, there may be issues relating to time that has been given, there may be issues that relate to possibility. But whatever the issue is, it needs to be outlined that this is the level of service that we are expecting, so that we don't fight about it later. The issue of payment, I think, goes without saying. When is payment going to be made? When what happens? Is it when we deliver, or is it when we've delivered and when the other party has signed off that they are happy? Or at what point, is payment going to be made? Is it going to be part payment and then the other payment going to be made when? But the issue of the payment clauses in SLAs goes without saying. It has to be, make sure that it's there and you understand fully what it is about. Reporting obligations, be very clear around those, whether you are going to be the one reporting or the other party is the one that has to report to you. Make sure that the format of the report is agreed, and who signs off that report, and so that no one holds the other party hostage to say, I've reported, but then suddenly the other party is raising an issue that the report doesn't have XYZ. Make sure that there is clarity around reporting obligations. And what's going to amount to critical failure? What is going to be amounting to a breach? Are there certain breaches acceptable and others not acceptable? I know I deal with particularly these in detail in the other course that I do. I'll tell you about at the end, where I go into great detail around what amounts to a breach and what does not amount to a breach, because not every breach you can cancel. There are certain breaches that do not necessarily result in a cancellation of in an automatic cancellation, but there are also breaches that result in automatic cancellation. But you have to be clear in the document what level of failure amounts to an automatic breach and therefore cancellation of a contract. And well, I think this is really just broadly, talking about where do you find, SLAs and so on. But I just thought that really I just emphasize in closing for me on the SLAs, the importance of having an SLA. An SLA, in fact, is your terms of doing business. And I know someone asked this question earlier when on the retainer. Everyone, if you're in any kind of business, you need to know what are your terms of doing business, and you have to have them clearly outlined. That document is the basic document you need to have for yourself, even if you sign other documents from other parties. But I must know that, okay, as a provider of a makeup artist or whatever service that I'm in, these are my terms of doing business, because this is then my SLA. And having that document, if I offer catering services or if I run an internet service provider, whatever business that I'm in, these are my terms, because what that does is it protects your business and it also keeps your sales. You don't want to just keep making sales, but there's no terms of doing that, because you are a ticking time bomb. Sooner or later, it's going to catch up with you, and you likely, when that happens, that there will be challenges. But I will also dare to say, having your SLA or terms of business in place, it improves your customer service because it clearly outlines your boundaries. It clearly outlines what you do and what you do not do. And if there's any argument, there's always a document that you can refer to. You know, if you're a furniture business that manufactures whatever it does, there's always an SLA that says, this is what I do, this is how I do it. And you're not therefore likely to end up in courts and in all sorts of things if you at least have a document in place that is objective, and it makes your business more attractive. I know that attractive, whether to other higher level customers, or even if, you know, down the line, you are really looking at building a business to sell. Because what you are doing is that you are making sure that your business, you don't run your business on a you know, from the back of a matchbox, but everything is formalized. When you have got, you know, a potential buyer or a potential investor, they can look into your terms of business. You can show them, these are my terms of business. And so that means that your business is more attractive to clients as well as potential investors. So I think it's important to really focus on making sure that you've got your legal agreements fully in place and you look legitimate. I mean, you are legitimate, but sometimes not having legal agreements and SLAs and terms of business in place can kind of, you know, make you not to look as formal and as legitimate as you could be. And you may be losing out on putting out certain disclaimers and waivers of liability for your doing business. I mean, imagine you're a provider of you have a spa, maybe you have run a mobile spa, or you're a makeup artist. There's no provision around what if someone has an allergic reaction, but you don't have terms of doing business that puts a disclaimer to that or something to that effect, and then you find yourself ending up with lawsuits. So you do not want to put your business at risk. You do not want to risk losing those sales. You do not want to bring about confusion around what you do or do not do. And you do not want to attract a liability that you could have otherwise contracted out of if you had drafted terms of business or SLAs for yourself. Thank you, Mandisa. I will end there.
Awesome. Thank you so much for that, Zama. Sure. Thank you for that. I think the best part of an SLA is that you get to protect all parties involved, and from all angles, really, if you put the detail in there, and it serves as a great guideline. And on the back of SLAs, can you maybe comment on the importance of agreeing on communication language, frequency, and mediums of communications like email, face-to-face, and use of minutes, as well as the storage of this engagement?
You say, can I comment on that, saying it can certainly be provided for in the SLA, maybe under that reporting section, that this is how frequently the reporting is going to be done between us. And this is, I mean, obviously now the issues of POPIA Act come into play. And as I said, there's probably another webinar altogether that we can really just break down what the different businesses need to provide for. But certainly it's important to outline the reporting obligation, the communication, and who to communicate to, because sometimes I've found that a lot of SMEs have been held hostage by saying you submit a report and then be paid. But then you submit a report and the person is supposed to sign off the report and they refuse to sign, or they say they're not there, no one else is doing it, and then you end up not being paid. And because those things were not outlined in the agreement.
And the agreement. And then maybe, are there any dangers to not stipulating how this engagement will be stored, or how the minutes will be stored, how the reports will be stored?
By stored, you mean like how they're going to be
maybe filed or shared with other parties?
Oh yeah, yes, of course, because not only that, you're likely to expose yourself you know, in terms of the POPI Act. But certainly, you know, between, you know, the issues of confidentiality, because most of the standard confidentiality clause, it is an automatic breach that the one party can cancel automatically, and they cancel, and not only that, they can cancel and claim damages if the one party has made information available to third parties and so on. So don't skim through those general clauses, because that's when you have clauses like confidentialities and waivers, and those can really land you with a damages claim.
Okay. And then, do email and telephonic responses, are those legally binding? If not, why not? And what do we need to do to make it legally binding?
Well, firstly, I think we spoke about earlier that that, you know, you can have verbal agreements, you know, you can argue at them, so they're not automatically illegal, except of course for certain types of contracts, and we did talk about those earlier. And I always say that, you know, reduce everything in writing. It's reducing everything in writing.
Okay.
Whether it's at the very minimum, you know, email, even WhatsApp. There's been cases where WhatsApp evidence has been admitted. So at the very least, it starts with that WhatsApp evidence. It gets followed through with an email. It gets followed through with a formal letter that makes reference to a clause in the contract that provides for that change, because sometimes you can have a provision in the agreement that says no amendment to the terms of the agreement will be valid unless signed by both parties. So if there's a clause like that in the agreement, you can't then say, oh no, someone from the office called and said we must change this. But the agreement says no changes will be allowed unless they are signed by both parties. So that then means you always have to go back to the standard agreement and make sure that whatever additional changes you are doing are in line with that agreement. Otherwise, you will have a difficulty considering them to be valid.
Sure. Okay. And then we've got a question from Clarence. First of all, he says, thank you for a great presentation.
Thank you,
and then the question is, does the SLA form part of the governance framework interactions with the client as part of the periodic matter managed, or is it separate?
Well, it should be a starting point, in my view, with the client. So it must always be the standard way it all starts. That once we have once you've been, your services have been secured, and then obviously the relationship is going to be governed by the terms and conditions of this SLA. So at all times, we are all, you know, governed by the SLA. So it is an absolute critical governing document between the two parties. Hence, all the details around the whole relationship must be outlined in the document. Yeah.
Okay. And then just our last question that takes us back to trademarks. So in terms of trademarks, are you able to confiscate or repossess a website or domain that infringes on your trademark?
Well, you would have to have an order. You will have to have an order of court, because you can't, in the same, I mean, you in the same way that you can't go and legally repossess property that you think is yours that is in someone else's hands, but you need to initiate a court process, initiating a process that starts with written notice. That starts with the written notice to that party that we are aware that you are da 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 da. So and so you are hereby given notice to remove and otherwise, we seek an interdict against you and so on. But ultimately, the actual act of taking down, you probably need to, have a court order that gives you a right to do that. But as a start, written communication, making them aware of such is a place to go. Immediately then follow it with a lawyer's letter that leads to an interdict.
Okay. Malusi says, hi, thank you for your insightful presentation. I supply mechanical machines called air blowers for lease and also monitor the condition on behalf of end users during operation. They have very high production rates, some in the millions of rands per hour. I don't want to be liable for production losses, but I want the business because it's subscription payments. What are key legal components that I should incorporate into the SLA?
I tried to listen very, when like, okay, I would otherwise take 5 hours to read through the business process. And when I do legal due diligence for businesses, now I was trying very quickly to listen to his business process so that I can see where are all the areas that that I would need to poke. I really I'm afraid I didn't catch all of them. Yeah.
I think, from reading what he has shared with us, first of all, he supplies machines, but in addition to that, he looks after the maintenance of these machines. So while the machines are on site and operating, the production rate can go up to millions of rands per hour. And I'm assuming that should something happen to the production, will that then be his issue?
But before you say that, even Mandisa, by saying you supply machines, are you selling them or are you leasing them?
He's leasing them.
He's leasing them.
Yeah.
He's leasing them. They belong to him. Oh, okay.
Yeah, they belong to his company.
So they belong to his company, and then he's leasing them. So the third parties are the ones using the equipment, and he maintains it. But then he doesn't want to. Which part does he not want to be responsible for?
To be liable for production losses
as a result of downtime.
I'm assuming so, because the only way, well, not the only way, but one of the ways the third party can lose production is if maybe his equipment has an issue.
Yes, I was gonna say that. That's what I thought, that okay, so in the event that the one of the machines is not working, and therefore then there's downtime. I think most of it's always a negotiation. I think that's why also I said at the beginning around doing your homework and having a strategy and an approach on how you're going to negotiate, and take firstly a business view. That's always what I say about legal agreements. Let the lawyer then tell you at the end, okay, maybe what's legally possible or not possible. But first, have a position from your own business view and what will make sense for you as a business owner, as the owner of the machines, but also for your client. Just maybe take it just in that plain common sense view that, okay, really, I can only be liable up to this, but not up to that. Only when this happens and that happens. Just firstly craft that even for yourselves, even before getting a lawyer involved, because you are the one that knows best what your clients will be, will accept, and what won't, take you out of business yourself, because you can agree on anything. And so you can then maybe take a chance and even then have that discussion with your clients, or position that to your clients that, okay, my offerings is on this basis. I would be liable only for this or for that, and then these are the terms. And maybe it's when you engage with the clients that you will get to see what's acceptable to clients and what is not acceptable to clients. But at least for yourself, you have made a business decision for yourself, something that makes business sense for you.
Yeah. Yeah, and just to see where do you draw the line, but have the conversation.
Yeah, where do you draw the line?
Yeah. Okay. SLAs and projects are subject to monitoring and evaluation or audits in the private sector. Is it recommended that the SLA have a declaration that the delivery of the SLA content between two parties may be subject to an audit and therefore be accommodated in the planning of the SLA?
Yeah, I guess the auditing process will fall under the reporting obligations as well as maybe the approval process, because and the level of service, because you will outline in the SLA what will amount to acceptable level of service. And if the level of service will be determined by an audit, then you can build that into the SLA that that only after the audit has confirmed XYZ, then will payment be made, or this portion of payment will be made on delivery, but the balance of the portion will be made once the audit has confirmed, and so on. So once again, you can definitely, play around with that.
Yeah, I think especially this particular business owner would understand their business process best. So it's a matter of taking that into consideration when building the SLA and putting that together.
Yes, and see what's going to make sense for their type of business, because different types of businesses have different cycles, and some depend also how long that audit is going to take, because then it means you need to also include in that agreement the processes on approving who the auditor is, because that in itself then may be an issue. Who's going to determine who the auditor is, who's going to pay for the audit, and are they fixed timelines to the audit must be done by a particular period, otherwise what happens? So then these are some of the clauses that you must make sure are in there, otherwise you can be held hostage under the name of, no, we're still auditing, and it's never ending.
For sure.
Yeah.
Okay, then if each page of a contract is not initialed, is it deemed incomplete?
Even that, it depends on which types of contracts, because certain types of contracts have fixed signature requirements, and other types of contracts, the initialing of each page is not necessarily an issue of legality or illegality. Having said that, though, the issue when you want to claim a compliance with clause 6.5, which is not initialed, and you both come to the table and your 6.5 page looks different to the other party's 6.5, and there is no way of telling which 6.5 is which, is exactly the reason that you do want to initial, because then it just makes the arguing that point even more complex. So even if in terms of the law, you for your particular agreement, you may not be required to initial that page, but it is just going to make your life very complicated potentially down the line.
So rather just get through it all.
Absolutely.
Okay, Andrew says, thank you very much for an informative session. And his question is with regards to SLAs and contracts. So with both SLA and contracts in place, the client and my employer outsource on-site has bridged the agreement. How do I address this in a legal way?
They have breached the agreement. If they have breached the agreement, then the agreement must outline what is the process in the event of a breach. And typically the process in the event of a breach, there'll be an outline of, is the notice that gets given, notice of a breach. There's an opportunity provided for fixing of the breach. There is maybe the agreement, does it provide whether there's damages that can be claimed, and what is the extent of those damages, in fact, I think this person must go into into the course on Udemy. There's a whole module that I have on there that really outlines how to break down what happens to the contract once there's a breach.
Okay, awesome.
But hopefully I've been able to give high level though.
Yeah, I think high level. That does bring us to the end of our questions, but Zama, I do want you to share, please, a little bit about the courses that you do offer and how one can find those courses.
Okay, well, thank you so much, Madis. I think, thank you so much for everyone that attended. I hope you found the session useful. And as I said at the beginning, really my passion is to make law as simple as possible and as business relevant as possible, and empower all of us, with this information. And one of the ways that I've done it is I've developed a course. It is called The Basics of Business Contracts, where I go into even greater detail around some of the principles that I've shared. It is available on Udemy. Maybe I can we'll see if I can share the link with the Innovator Trust. They can share the link for the course with everyone that attended, if that is okay with them. But you can go online. You can also just link up with me on my social media platforms. LinkedIn, Zama Mkosi. It is Mkosi with an M. Oh, you've seen Mkosi Inc the whole 2 hours, so hopefully you won't mistake that for Mkosi. It is Zama Mkosi on LinkedIn, and I also am on Instagram, and I share a lot of information around business development generally, but also particularly on the legal education side of things. But I also offer other, legal support and legal advisory services for more specific issues. But I focus a lot on legal education and training.
Fantastic. Thank you so much, Zama, for that and for this really informative session. I mean, I myself have learned so much, and I've got no doubt that all our attendees did find this valuable and walked away with something to think about, as well as to how they best apply themselves in their businesses, in the processes, and in protecting themselves and their business and their third parties involved there. So thank you very much for that. We truly appreciate it.
Thank you.
To all our attendees, please be on the lookout in your inbox. We will be sharing highlights, as you know. So please be on the lookout. Please feel free to reach out to us if you have any additional questions, or if there's something that you thought of after the session, please pop us a mail and we will address that the best way that we can. But for now, thank you very much. Goodbye and enjoy the rest of your day. Zama, you've been a superstar, so thank you.
Thank you. Thank you so much for the opportunity. Enjoy your day.
You too. Bye, everyone.
Bye.